Then why did you lie in your motion? You shouldn't practice criminal defense anywhere.
When this defense lawyer filed a motion claiming a breakdown in communication, the judge realized he had never even spoken to his client and removed him from the case.
Good afternoon, Judge James Murray, P 5490, appearing on behalf of Mr. Jones on the subsequent matter. Great, this is the time for my motion to withdraw. First of all, I want to apologize for inconvenience of court. If so,
I'm trying to figure out what's the basis of your motion to withdraw.
the basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. Was never without action. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? Because all this has done is delay Mr. Jones's matter.
Understood, Your Honor. I do apologize for the inconvenience.
Well, it's not just apologizing to me, it's Mr. Jones. He's got a right to have his matter proceed forth, and now has the discovery been sent? I mean, where is his case at this point?
I have not received discovery of this matter, Your Honor.
He was arraigned on March 2nd, and so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later, and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. And certainly not here in Washtenaw County. If you were going to withdraw, then you go ahead and you get the evidence. At least then, when new counsel steps in, you can turn it over to him. But you don't do this way, and you don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she represents.
Do you have a copy of your motion? Look at paragraph 2. Read it out loud. What does it say?
It states that there has been a breakdown of communication between Attorney James Murray and
How is there going to be a breakdown if you never talked to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court, is what you should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to
No, you did mislead this court. When I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it. You never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him? You shouldn't practice criminal defense anywhere, because your primary obligation is to your client, not his family, to him. For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you. Don't come back into this county until you're ready to practice like you should practice. Goodbye.
Anything on your stuff?
Goodbye.